Good afternoon. Thank you for taking the time to attend our third Employment Handbook webinar this year. Today we're going to focus on discrimination, retaliation, and other considerations. My name is Carl Habekost. I'm a labor and employment attorney at the law firm of Bugbee & Conkle. And we also have Elizabeth.
Hi, everyone. You're going to introduce me?
No, you can introduce yourself.
So my name is Elizabeth Bolduc. I am a labor and employment attorney here at Bugbee & Conkle, and we're excited to wrap up the final series or webinar in the Employment Handbook series today with you all to talk about discrimination, retaliation, and other rule sections.
Yes, Elizabeth, thank you for putting this together. This is an excellent PowerPoint. It will be a resource down the road because Carrie will make sure that we get it on our website at some point. All right, let's move. Why do you need a handbook? Well, here are some of the reasons. It helps to set the culture. It provides expectations for employees and also for supervisors and management. Actually, what it does is sort of lays out and describes expectations for everyone in the work environment. It can communicate important information. It's a reference tool. And importantly, as far as we're concerned, being labor and employment attorneys, it helps to reduce an employer's legal liability. There are advantages to having a handbook. Feel free to chime in anytime. It helps to orient new employees. It provides consistency. And if there is a takeaway today, consistency is one of the primary words. It helps the supervisors to be consistent in the application of the work rules. It helps you to be consistent with providing benefits to your employees. As we already said, it sets expectations, it reduces confusion, assuming that it's well written and clear and makes sense for your company. And by the way, I suppose at this point, since the next little thingamajig is provides leadership, it's important to have a consistent and clear handbook, but what is more important is that the company actually follows it so that you don't have actual applications and processes that are contrary to what the handbook policies are.
And since we're on this, I kind of just want to echo what Carl said. We don't have a separate slide, but I know these are all kind of principles we've talked about throughout this whole series, and we always like to start out reinforcing these principles. But there are many advantages of an employee handbook, but a bad or a poorly written employee handbook can do a lot of harm. And so that's why we've spent a lot of time from the past year to go through in big detail all of these little policies that make up one big employment handbook. And so what happens when you have a bad handbook is the policies are written poorly and they don't relate to one another, they don't fit your culture. And so I just wanted to point that out since Carl made one little side note about it. You know, if you're not applying it consistently or you have policies that contradict each other or aren't even applicable to your workforce, it's going to create a lot of confusion and it could actually harm you. So I just want to make a little side note there on that.
Well, and actually to tag on to what Elizabeth just said, since I've heard her say this many times, it doesn't have to be a legal treatise. You don't have to come up with every possible situation in the world that could apply to your workplace. It's just a basic statement of what your culture is, what you expect the employees to do, and what management is going to do. So here's a sample of elements of the handbook.
And for those who have been following along the whole series or, you know, just found out today that there was a series and you go back and watch the previous PowerPoints, this is a graphic that we have used throughout the whole presentation to kind of give a layout, and then depending on what that seminar or that series is addressing in that day, it will point to that graphic. So right now we're at number 8, which is talking about the rules and regulations, which is really the meaty part of the handbook, because that's really where you're going to communicate to your employees the rules. What do you expect from them? How do you have to behave, and what are the consequences?
Well, first let's go ahead and disabuse you of any confusion that you may have that the National Labor Relations Board only applies to union settings. That is absolutely not true. Over the last 10 years or so, the National Labor Relations Board has been very active in the private sector involving non-union employees. Why is that? Because the National Labor Relations Act applies to any issue involving wages, hours, terms and conditions of employment. They're known as Section 7 rights. An acronym is WHAT, wages, hours, terms and conditions of employment. So we're going to talk just a couple of slides about that. Well, what do we mean when we talk about National Labor Relations Board? The National Labor Relations Act goes all the way back to the 1930s, and the board is an administrative part that was developed to implement the National Labor Relations Act. So it's an independent federal agency that improves or helps to improve wages and working conditions. It consists of the actual board. That's a 5-member board. They're political appointees. There are judges, administrative law judges. They are from all over the country. There are regional offices all over the country. And for us, where we're located in Toledo, Ohio, and actually most of Ohio, we're in Region 8. So now that you have a sort of visual idea of what we mean when we say the National Labor Relations Board, they have applied the National Labor Relations Act to virtually all private sector employers. So what the board has been commenting on very actively since about 2007, 2008 is certain rules and regulations that are in handbooks. And the board has said it's unlawful to compromise employees' Section 7 rights. That's what I just talked about, as called the what. So some handbook rules compromise, according to the National Labor Relations Board, those rights. A very big case came about in December of 2017. Give you a quick background. There was something that was called the Lutheran Heritage Test, and that had been around for 20 years or more. It required some mental gymnastics, and it wasn't real clear. The National Labor Relations Board took on this case in 2017. It involved the Boeing Company. The Boeing Company had a rule against taking pictures and videos. Why? Because Boeing designs and manufactures military and commercial aircraft, and they had a lot of private information, confidential information, and they had a rule generally that said no taking pictures, no video. There was a complaint filed that violated the wages, hours, and terms and conditions of employment because some of these employees felt that there were some unsafe work issues in the factory. And the board addressed this, and they said having a rule that is neutral on its face is not wrong. And under the old Lutheran Heritage Test, the board had to go through all kinds of convoluted gymnastics to determine whether or not having a rule such as no taking of pictures was in and of itself unlawful. The board had moved to the point in 2015, 2016, where if you had a rule that said no taking pictures, and it could be interpreted to violate wages, hours, and terms and conditions of employment, then it was unlawful. So now the Boeing case really enunciated some clear guidelines, and they come into three categories of rules. Generally lawful to maintain. And here is a list of some of the rules that the National Labor Relations Board in this Boeing case said are lawful to maintain. Things like, you know what, be nice to each other. Don't go screaming and yelling at each other. Don't defame the company. It's okay to have confidential provisions. We can identify people who can speak on behalf of the company. Then some rules that were warranted a little more scrutiny, and they're listed there. Off-duty conduct that might be harmful to the employer. That's something you really have to take a look at.
And can you explain, Carl, for everyone why these would warrant a little bit more scrutiny, or at least why the NLRB believes so?
Yeah. Disparagement of employer. Let's talk about that. If you're upset with your company and you go on social media and you complain, maybe about a supervisor of the company, that is protected activity if you're talking about work. Just plain disparagement of the company, saying that Jimmy John's sandwiches suck and, you know, they're the worst product in the world, don't buy them. That doesn't have anything to do with terms and conditions of employment. So a rule like that, you have to think a little bit about how you're going to apply it. Do you have any comments on that?
Yeah, so I just wanted everyone to understand the reason why the NLRB will think twice about a policy. And so if you ever have to think, would this affect an employee's right to talk about wages and hours, talk about working condition, or even try to collective bargain, then you might want to take a pause back and say, maybe the NLRB might not like that.
Right.
And so things like, you know, like we just talked about, disparagement of the company. If you really want to say that you want to form a union and you're not even allowed to use the company's name on social media, that could, you know, could in effect violate your Section 7 rights.
Correct. Let's just go ahead and do one real quick example of a clearly unlawful rule, and it's one that we see in handbooks that our clients give us to take a look at. No discussion about your wages and what you earn. Don't talk to anybody about how much you earn. Now, that is clearly unlawful. From our perspective, an employer might have a reason to want to maintain their earnings of the employees confidential, but employees are allowed to talk about that.
Yeah, so the difference between here is while the employer might have a reason to keep things confidential, and the employer always can, but requiring the employee to keep something like their wages, their hours, confidential, that's when it violates their Section 7 rights, because they do have the right to talk to others about those things.
Correct.
All right, so for those who like kind of checklists of what is on the agenda today, you know, these are kind of the policies that are typically found in the rules section of a handbook, and we're going to go through some of the bigger ones to talk about, you know, what a good policy looks like, what should be included, what should be excluded, and what is the rationale of having some of these policies in your handbook. Okay, so the first one is, you know, why do you have a rule section? And it's kind of what we talked about in the very beginning, because you want a communication tool to tell your employees, you know, what are the rules, what are the expectations, here are all the things that you should follow, and can help prevent problems in the workplace. So it can reduce discrimination because employees know, for example, what is prohibited in the workplace, and they know they could be fired for it. So typically when someone has knowledge of those things, they will not engage in those types of behaviors. And also, if there is an issue in the workplace, then they know how to address it, who to talk to, and it can help reduce your legal liability should anything come up. All right, so this is a big one. Code of conduct is one we see a lot of times in handbooks, and it's a good thing to have so long as it's thought out and it fits your culture and the company's values. So what I was talking about earlier, that sometimes policies don't really reflect the company's values, it gets really confusing for employees to follow. And this is the same thing here. You don't want to take a code of conduct that you found on maybe a template or Google when it has no application to your business. So maybe that one had to do with the transportation industry, and so there's a code of conduct that within that industry. But you work at Amazon and there's a warehouse, and it's definitely not the same type of culture and the same type of value. So you just want to be cautious of that. So here you would just want, before you even get into your disciplinary process, is to kind of lay out the expectations that you have for your employees that does reflect your culture, provides a foundation for why you find those things offensive or why they are prohibited in your workplace, and then what happens when someone's violating it, and then how they can inform others if they witness someone else. That's kind of the basic gist of that.
A question: would this be something like a lot of the handbooks we see, like at the disciplinary section where somebody violates the rules and there's a disciplinary procedure?
Yeah.
Okay. All right.
And so we'll just touch briefly here. So you can have multiple types of different disciplinary policies, and that would, as Carl brought up and I mentioned, it would flow. There's multiple ways of doing a disciplinary process. You can have a progressive, so step 1, step 2, step 3, or you can have it just, I've seen, a multitude, like these kind of actions, like being late or yelling at a customer, result in these types of disciplinary consequences. But, these types of things equal termination. And so just to go off, Carl, what you were saying before we jump into harassment, that's how that would fall in there. I thought we had a slide on it, but I guess not. Okay, so next is the biggest one. So we're going to talk for kind of a long time about discrimination and sexual harassment, regular harassment, because that is what we deal the most with as employment attorneys. A good policy can go a long way. So a policy is a huge defense to employers when someone ever complains or sues on discrimination or harassment. So there's defenses if, in fact, you have a good policy and the plaintiff or the person who is alleging the complaint did not follow your policy, but was made aware of it. And so that's why it's really important to have this policy. So if you get into the position where you have to defend your actions, you have something to point to and provide, the court with a reason. So what does a harassment policy look like? So we kind of put together a checklist. So first and foremost, you're going to want to say, what is harassment? Let's define it. Give a definition. So under the law, that is what we call a FLUAR. So it means that it can't be anything less than. But you as an employer can make a broader or a more encompassing definition of harassment. So under the law, it's a protected classification, which means sex, age, gender, national origin, disability, religion, GINA, so your genetic information, the list goes on, but that's pretty much the major ones. And so treating others based on those characteristics is considered harassment. And you should have an affirmative statement saying that this company does not tolerate these types of behavior. I will caution, a lot of times I've seen in companies' policies that we have a zero tolerance for these things. Well, courts have come out to say, and even the EEOC has come out to say that, we don't really favor these things, because what does a zero tolerance mean? Are you just going to terminate someone because they made one offhand comment when you could have just educated them? So I prefer, it's just my preference. I mean, there's a lot of debate about this in the legal field, to say that you do not tolerate it, but to have a zero tolerance is almost too strict, and then it can have the adverse effect. So people aren't coming forward because they think it's too strict, and it kind of defeats the purpose. So that's just my experience that I wanted to share with everyone.
Well, that makes sense. So rather than say the company has zero tolerance, blah, 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 it's probably better to say the company does not tolerate harassment and anti-everything.
Yeah, absolutely. And that's kind of a good principle for all these policies. You don't ever want to have too strict of a policy, because, you're dealing with individuals. Depending on how many individuals you employ, it could be under 10 or it could be thousands. And we all have, as employees, individual needs that sometimes need some wiggle room. And so when your policy is a little bit too strict, it can actually do a little bit of harm. So that's why I wanted to put that little tip in there. So then after you define, what harassment is, saying that the company stands on harassment, so that it doesn't tolerate it, it wants everyone to be treated equally, it values, you're going to want to make sure that you have a description of the reporting system. So, okay, someone looks at your policy, they say, oh yeah, what is happening to me is defined as harassment. What do I do about it? Where do I go? And so a good harassment policy will lay out the steps for that employee or to report what's happening. And guidance has come out to say that you want to give more than one mechanism of reporting. So what if it was the HR director who was in fact harassing the individual? If they can only report to the HR director, then it defeats itself. So if you have multiple avenues, so the HR director, your supervisor, really anyone in leadership should be able to handle those complaints and report it up into the company. So those are very important things that you'll want to point out in an anti-harassment policy. Also, I know
the NLRB is that the company discriminates against certain kinds of information that can be posted on a bulletin board. You really have to take that a case-by-case basis. Do you have any comments on this, Elizabeth?
Yeah, absolutely. So I know bulletin boards may be phasing out. So it would be my recommendation if you have like an internet website that serves as a bulletin board. I think that's like the most common way employers are now communicating with employees, or by a hub online. These kind of principles would apply there because, right, it's the same thing. Employees are posting things that they would have back in the day on a bulletin board. So that's just kind of my 2 cents there. But yeah, if you're going to allow Janet to post her Girl Scout cookies on the bulletin board, then you should allow other types of similar speech. But if you're going to restrict, people to only discussions about work, then it's facially neutral when it comes to like union activity. So that's a lot of times where we see this get messed up, is when an employer allows an employee to post their kids' popcorn sale, their kids' candle sale, their kids' cookie sale, but they don't let other employees post, we want to collect and bargain with this union, sign our agreement, or whatever the case may be. That's when the NLRB comes in and says, no. Now you have a hostility towards pro-union activity. All right. So a lot of times we get questions about, what can we do about people handing out leaflets, right? So flyers about their church fundraisers, or maybe union activity, or maybe fundraisers at the kids' school, things like that. And so you have the right to prohibit employees from distributing any types of materials whatsoever during their working time. So means when they're engaged in doing their job duties, but not when they're off the clock. So not in the break room, not when they're on the sidewalks, not when they're all going out to get lunch. And so you want to be consistent when applying these types of policies. If you allow some type of leafletting or handing out flyers, you're going to want to apply to all. Of course, you can make an exception if there's, offensive things are a little bit different, but for the most part, that's the main rule here.
Social media. Companies really cannot operate without electronic transmission of data and electronic communication. More and more, that is now including the big social media accounts, Facebook, Twitter, LinkedIn. And who owns the LinkedIn account, by the way? That's really my ongoing resume. And I had a LinkedIn account prior to becoming an attorney at Bugbee and Conkle. Who owns that? Did you have a LinkedIn account before you started to work with your company? It's always a good question. I mean, Facebook account, same thing. However, the information that is put on social media can be regulated by the company in a careful fashion. Always start with the premise that employees are allowed to discuss wages, terms, and conditions of employment. If they're doing that in accordance with the law, then your social media policy cannot impinge on that right. Otherwise, then we're going to go back to what we talked about before. What do your policies say about disparaging the company? What about, giving confidential information out on social media? So you can control that. We spend a lot of time doing social media policies. We could probably do a 30-minute webinar on social media and the policies. And it also, by the way, for those of you workers' comp people, is a great resource to get information when you're investigating injuries and when we're doing investigations on behalf of our clients for other employment-related activity. It is amazing what people will put on social media. Anything else you want to?
Yeah, what about prohibiting employees from saying that they're speaking on behalf of the employer?
Mm-hmm. Sure. You can have a policy, and you probably should have a policy that precludes employees from saying they are speaking officially on behalf of the company.
What about like discrimination on social media? So, making a comment that is offensive to a coworker, but it's not during the work time, but it's on Facebook.
Yes, I think you should have a policy against that.
Yeah, so these are all kind of, those are kind of considerations that social media policies address. So, although you're free to operate and continue to post on your social media account, just make sure that you're not speaking as a representative of a company and distinguish that you aren't. And any communication that you have to other employees on these platforms could violate another policy, such as the discrimination or harassment policy. And so those are some inclusions you should definitely think about when you're talking about social media.
By the way, that was just great because Elizabeth and I did not plan this. So that was, it was excellent questions. Really revealed the gist of the slide. Confidential information, this is sort of what we talked about, and this is a recurring theme. It's a pedagogical technique where we circle back around on information we talked about previously. As long as you're not precluding individuals from discussing specifically the wages, hours, and terms and conditions of employment, then you can have a policy that prohibits giving information concerning customers, disclosing confidential financial information about the company, business partners, private information to employees, etc. Anything further on that slide, Elizabeth? Okay, let's move on.
All right, so we're towards the end, so no one fell asleep quite yet, or if you fell asleep, wake up. So, company property, this is a big one because, as technology is changing and as the workforce is changing, now you're giving employees cell phones, you're giving them maybe vehicles, you're giving them laptops that they could take to and home from work. And so this is something that obviously, as we've been harping on, has to be unique to what you do and how you operate. But you're going to want to identify the company's property that you are leasing to or the employees, right? So these are all the types of things we're giving you during your employment here. What if they break it? What if they throw it out the window because they're having a bad day? We've been having a lot of IT problems, and, that's something I've considered. So what if other employees are like, I'm over it, I don't have to pay for it, I'm going to stop on my computer. What are the consequences? Are they going to have to pay for it because it was, their intentional act? Or what if, they accidentally spilled their coffee on it and it wasn't intentional? Are you going to pay for it? So you can hash those types of things out there, and then that way it's no surprise when your employee throws their computer out of the window and they're told that they have to pay for it. Also, what about disciplinary, if they misappropriate that, could they be disciplined or could they be terminated? And so that's just kind of the overall scope of that. You also want to talk about personal use. So I know a lot of times companies are now moving to, at one time it was, don't use this for anything other than business needs. And now companies are like, we don't freaking care. It's unlimited data. It's your phone. Let's not have two phones. We would rather just have you accessible at all times and just have the one phone. So use your personal, do whatever you want, but you need to set the scopes of it, right? So even though you're using it in your own personal use, you can't do things that are harmful to the company. So like, look at maybe a unlawful website or gambling online or sending harassing text messages to your coworker in the other room. And then you also want to say, hey, this is our equipment. This is our server. This is our email account. We have the right to go in there and monitor it. And you can be disciplined if you don't follow that scope that we laid out just a few minutes ago. And then also you should let them know, hey, you really don't have a reasonable expectation of privacy here, because we do own these things. We are going to check up on you. If we have a ticket that is flagged that you're looking at something wrong, we're going to validate it, or we're going to look at it. And if you have been found to look at that bad thing, you could be disciplined. So those are the kind of the main parts that you'll want to cover in that kind of policy.
Last slide.
And so, you know, we won't go into too much detail, but these are just also some miscellaneous things you might consider. You know, electronic communications kind of falls a little bit into what we've talked about throughout this whole thing. But, you know, now there's Skype in the workforce. Now that there's all these things, emojis, you know, can you send certain messages that, you know, could be harassment or could be discrimination? And so just be cautious of that. Moonlighting. Maybe you don't care that your employee has another job. Maybe you do. Do you care if you hire family members, or as long as they don't work in the same department or under the same supervisor, or one doesn't report to the other? Do you allow employees to date each other? So these are some other really small policies to consider in the rules section.
Yeah. Well, I think we did it pretty close to 60 minutes. Thank you for attending. Before we double check, see if we have any lingering questions, we will release a news blast when the United States Supreme Court addresses what is a very important issue of the LGBT cases that are up there, because you'll need to know about that information. It might possibly mean modification of your handbook policies. Any questions, Carrie? Nope. Anything further, Elizabeth?
Nope. Thank you all for your attendance today. Thank you.